Hello, I'm Dr. John Kavanaugh, and this is AJS101, Introduction to Criminal Justice, Lesson 9, Part 1. This lesson is about sentencing the guilty. Sentencing is the imposition of a penalty upon one found guilty of a crime. And judges impose sentences with input from primarily prosecutors, the defense attorney, and the victim. However, in some capital cases, the jury decides on imposing the sentence. So in a capital case, the jury not only decides guilt or innocence, but then in a separate deliberation, decide between life imprisonment or the death penalty. And by the way, in terms of the victim having input, that is a very important part of current sentencing, and many states, including Arizona, have enshrined in their state constitution the right of a victim to have input into the sentencing of the perpetrator who victimized them. And if the person's on parole, the victims even have a right to appear before the parole board to argue for or against early release from prison. All right, let's talk about the philosophies of sentencing. And by philosophies, we mean the reasons, what you think sentencing should accomplish. And this is important because depending on what you think the purpose of sentencing is, will determine what kind of sentence you support in law, or if you were a judge, within the constraints of sentencing guidelines you would impose. And the major sentencing philosophies are retribution, incapacitation, deterrence, rehabilitation, and restoration. Now, don't think that you have to pick one of these philosophies, or each state has their own single philosophy. Many of these philosophies work together. Retribution, incapacitation, and deterrence are quite compatible with each other, as we'll see, as are rehabilitation and restoration. So a person can hold more than one philosophy. Let's talk about the first philosophy, which is retribution. And retribution is taking revenge on the criminal perpetrator. It is the oldest reason, and it is epitomized in the biblical phrase from the Old Testament. I'm sure many of you know this: an eye for an eye, a tooth for a tooth, a son for a son. Today, retribution is supported by those who believe in the just deserts school of punishment. And this emphasizes that the criminal deserves punishment for the bad act he or she performed, and that the punishment should be proportional to the severity of the crime committed. And retribution is the dominant sentencing philosophy today. And in fact, it always has been for the most part. The next philosophy is incapacitation. And incapacitation uses imprisonment as a way to remove the criminal from society so that they can't harm people, or it uses some other means of control to reduce recidivism. And as we discussed earlier, recidivism is repeat offending. Now, imprisonment, especially during the young crime-prone years, is the most popular form of incapacitation. There are many sentencing programs where if a person is convicted of a crime, they'll look at his or her criminal history. And based upon the number and type of priors, the age of the first offense, and other factors, they can statistically get an estimate, or guesstimate might be better, of the likelihood of this person recidivating. And if it's high, they give enhanced sentencing to keep these people in prison so they can't harm other individuals. And this especially is important during the crime-prone years, 18 to 28, 29, when most people commit most of their crimes. And we discussed that, I think, in the first chapter or the second chapter. So let's go on to the next philosophy of sentencing, which is deterrence. Deterrence is using punishment as an example to, and this is a no-brainer, deterrence, deter future offending, to make people think twice before doing it again. Deterrence directed at the offender and his or her behavior is called specific deterrence because it's specifically aimed at that individual person. And punishment that is swift and certain deters best. And that comes from the experiments of psychologists concerning conditioning. If you took a Psych 101 course, you might remember the classical conditioning and Skinner's box and Pavlov. Basically, they would have like rats in cages, and they would have levers, and they would get rewards and punishments for different behaviors. And the overall lesson was that when you're teaching somebody, and punishment is meant to be teaching if it's a deterrent, teach them not to do it again because of the penalty. If it's swift and certain, it's the best deterrent. Deterrence directed at society in general is called general deterrence. So when we punish somebody severely and it's publicized so other people learn about it, we do that so other people will say, wow, if you do that, you get that sentence. I'm not going to do that. That's general deterrence. All right, the next philosophy is called rehabilitation, and rehabilitation attempts to cure the offender. Now, this is based on a medical model of criminal justice. You see, historically, we had kind of a moral, religious philosophy that criminal behavior was bad and immoral and deserved punishment. Rehabilitation is part of a medical model. It became very popular after World War II. Science helped us win World War II. The atom bomb invention, they found a cure for malaria for the troops fighting in tropical regions. So America was very much enamored by science and medicine after World War II, and we wanted to apply it everywhere. We even had the space program. So in criminal justice, it was, hey, these people aren't ethically bad, deserving punishment. They're ill, they're sick, and they need treatment. That is the rehabilitation model. And education, especially job training, and psychological treatment like anger management are the tools of rehabilitation. But it's expensive. Programs cost a lot of money, and it unfortunately is not that successful. A lot of recidivism occurs from people in prison. So as a result, you don't have a lot of popular support for rehabilitation. But it is there. It's just not a major philosophy of sentencing. All right, restoration. Restoration is the newest philosophy. It's kind of liberal left-wing in its origins, and it came about, I guess, in the 80s. Restoration attempts to make the victim whole again by making the perpetrator do things that will minimize the harm done. Now, obviously, restoration is not used in the case of a rapist because you don't want to re-expose the victim to the rapist. This is meant for less serious crimes like property damage or minor assault or theft. So meetings with the victim, the payment of restitution, and community service are part of the restorative process. In other words, doing these things makes the offender whole. Doing these things makes the victim whole if there was in fact a victim. So that's restoration, kind of balancing things and restoring order and balancing the scales, undoing the harm. Indeterminate sentence. Let's talk now about different types of sentences. We're going to move away from the philosophies. Now what are the different types? So indeterminate sentencing encourages rehabilitation by giving the offender a range of years in sentencing. The offender is released when the parole board thinks he or she is rehabilitated or at the end of the sentence. So let me give you an example here. So an indeterminate sentence might be 6 to 12 years. So the person is sentenced to 6 to 12 years. And what that means is that person has to be in prison for the first 6 years. But after that, after the 6th year, the person becomes eligible to go before a parole board. And the parole board looks at their behavior in prison, what rehabilitation courses they've taken, how they scored in those courses, and decides if they have been cured. Remember, this is the medical model. If they think the offender is cured, they release the offender from prison, but under the supervision of a parole officer to make sure that they comply with the provisions of parole, which very often involves more education and medical treatment or counseling or what have you. So that's indeterminate sentencing. Unfortunately, rehabilitation is often unavailable in prisons, and instead, people are paroled based on just their good behavior. If they don't get into trouble, they're assumed to have been cured, which is not the case. A calculating criminal who wants to get out and do more crime will behave good in prison to get out early. Or the release might be because early release might be due to the need for more prison space because new prisoners are coming in and the prison's overcrowded. Indeterminate sentencing also allows judges and the parole boards to take mitigating circumstances into account. So if a person, did in fact steal something, but it was to get milk for their child or something like that, that would be a mitigating circumstance, and perhaps they would be more apt to release the person earlier in the sentence. Indeterminate sentencing is becoming unpopular, both with inmates due to its uncertainty and the public that thinks it lets criminals off too easy. Criminals don't like the uncertainty of not knowing when they're going to get out. To say you'll be released in 6 to 12 years puts a massive question mark over their lives, and people don't like the uncertainty. In fact, polls have shown that prisoners would rather have a straight 8 years and I'm out than a 6 to 8 indeterminate. So prisoners aren't too thrilled with it. In addition, the public thinks it lets criminals off too easy, because when a criminal gets off at the early part of the sentence and kills somebody and it's on TV, they say, "Oh my God, why did somebody get out so early?" "Oh, it was because of parole. We don't like parole." So parole's not too popular. By the way, prisoners can also get out early with good time credit. And good time credit involves serving one less day for every 2 to 5 days of good behavior in prison. So if every, say, 4 days of good behavior, they knock a day off of the sentence of the person. Correctional officers, do you think they like or dislike good time? Right, they like good time credit because it encourages prisoners to behave. If prisoners could not get good time credit and they knew that it was a determinate sentence and they had to be there for, say, 10 years, there's no incentive to behave because behavior doesn't get them anything really better. But when they know they're knocking time off their sentence, they will tend to behave. So it's a pretty good technique for controlling prisoners. Structured sentencing. Structured sentencing is the opposite of indeterminate sentencing, right? Indeterminate is kind of loose, 6 to 12. Structured sentencing involves providing less discretion to judges in sentencing by imposing determinate sentencing and sentencing guidelines. Now, structured sentencing came about due to complaints about sentencing disparities and a lack of proportionality in sentences. Let me go through each of these one at a time. Structured sentencing came about due to complaints about sentencing disparities. When judges have very wide latitude, some judges will be, easy judges and give very light sentences, and some judges will be stern judges and give long sentences for similar crimes with people having similar criminal histories. If you've committed the same crime as somebody else and you have the same criminal history, you really should have a very similar sentence, not a disparate one, based upon whether you got a stern or a really nice judge. So sentencing disparities are big differences in sentences for people with similar backgrounds who did the same criminal act. And, when these two criminals meet up in prison, they get a little upset. The one with the longer sentence. And what was happening, like in New York State and many other areas, were that prisoners who were sentenced for, say, a robbery with one prior in a rural area would get a very strict long sentence, because in rural areas they're more conservative and crime is not as frequent and people get really upset about crime and judges respond to that with harsh sentences. Whereas in cities there's overcrowded courts, plea bargaining, and crime is not as unusual as in rural areas, and judges would tend to give lighter sentences or maybe as part of plea bargaining deals. So when these two prisoners with the same criminal act and similar backgrounds wind up in the same cell in prison, and they always say, what are you in for? And it's the same thing. And the next question is how long? And the one's got 15 years and the other one's got 8. The 15-year guy is not a happy camper. So sentencing disparities are one problem that structured sentencing, less discretion for judges, takes care of. Lack of proportionality. Remember, proportionality is when the punishment fits the crime. A robbery should get a severe sentence, minor property damage, a minor sentence. And if judges have wide discretion, you don't get the same proportionality. So structured sentencing can give you better proportionality. And finally, the other criticism of indeterminate sentencing was overly short sentences. When these people got out real early at the start of the probation eligibility, the 6 to 12, they're out in 6. People thought that was overly lenient sentences. So basically what you do is you put in structured sentencing. It's determinate, and judges have less leeway in even setting that set determinate sentencing. So determinate sentencing is sentencing a defendant to a fixed time, but with time permitted for good behavior. Again, you got to encourage good behavior. Prisoners like determinate sentencing because, again, they know when they're getting out, and it also does away with parole boards. There's no longer a range, so that at the low part, so when you get to the low part of the range, if it's 6 to 12, you get to 6 years, the parole board evaluates you because there is no range. You're going to get out in whatever your sentence was, 6 years, 8 years, 12 years, what have you. Okay, voluntary or mandatory guidelines are rules for sentencing usually presented in tables that consider primarily the seriousness of the crime and the background of the defendant along with mitigating and aggravating circumstances. Now remember, these guidelines, when they're mandatory, that's how you reduce the discretion of judges. You force judges into a very small leeway area based upon the seriousness of the current crime and the prior criminal history of the defendant, and you might also allow a little less time for a mitigating circumstance, and a mitigating circumstance might be cooperating with the police, or you committed the crime to get milk money for your child. Mitigating circumstances reduce liability, culpability, blameworthiness. And under these guidelines, they could maybe add some time for aggravating factors. Factors like you tortured the person when you injured them. That you can increase the penalty, the sentence in this case. So mandatory sentencing gives judges less leeway in imposing sentences. And mandatory sentences are often given to repeat offenders. And these are often called three strikes laws. It became very popular back in the 60s when crime was going up and people were upset, that states passed three strikes laws, where on your third felony conviction, you had to have life imprisonment. Another type of mandatory sentence is one for a person who commits a specific crime. Some cities have mandatory sentences for gun possession. So if you're caught with an illegal handgun, like in New York City, you might get a mandatory 1 year in jail, which is pretty strict. So much for the Second Amendment in New York City. And by the way, I'm talking about possessing a gun, and that's your only offense. Obviously, possessing a gun when you commit a crime, that would be an aggravating factor, and it would make it a higher level of robbery if you were using the gun in a robbery, and you should throw the book at those people. Now, mandatory sentences may not deter crime, and they may also promote injustices, and they also can cause prison overcrowding because you suddenly start, you can't release people early, like in indeterminate sentencing, so there can be problems. By the way the guidelines work, this is a chart, as you can see, and the way it works is you have two axes. The horizontal axis is the seriousness of the crime, and as you move across, it's more serious felonies. And the vertical axis might be the number of prior convictions for crimes. So basically, the first thing that you do is you would find the seriousness of the crime. So you would be like in this column. And then you would see the number of prior offenses the person has. And then in that box, you would have a range of years. So if it was a low-grade felony with maybe 2 priors, it might say that the determinate sentence is 2 years, but the judge could maybe increase it or decrease it a bit, maybe by 6 months, based upon mitigating and aggravating factors. If it was a more serious felony and the person had like 3 priors, then maybe the presumptive sentence might be 15 years, and the judge could add or subtract 3 years based upon mitigating and aggravating circumstances. And that's roughly how these things work. And again, it's taking most of the discretion away from the judge. Okay, so that's the end of Lesson 9, Part 1, and you can now proceed to Lesson 9, Part 2.